Welcome to another episode of David vs. Goliath Podcast. Today, we're taking a little bit of a different turn. Stan, I think I'm interviewing you. And what we're going to discuss is kind of like your niche practice within your practice, which is you love to take on cases other lawyers have turned down and then turn that into gold. Like you take other folks, and I hate to use the word garbage because nothing's garbage, but where a lawyer's turned the case down saying to the client that it just doesn't look like there's any prospect for recovery. On 4 occasions in the past year, you've turned $0, not even offers, just case where they were told there's nothing here to do, and they hired you and you turn them into multi-million-dollar settlements.
Yeah, thanks. It's going to be an interesting topic because I find this stuff eminently fascinating because it's really not about someone had a crappy attorney or their attorney sucked and then they came to us and we're this great attorney. What it's about is different. Right? We're different. We're a second set of eyes. All of us as attorneys, we spend, after 20 years of doing this, 25 years, you start to get creative. You start to look a little deeper and pull on different threads. So what'll happen is over time, you sort of develop a different problem solving approach to it where you don't necessarily see it the same way another attorney would see it. So and I know every case you're talking about, I know each and every one of them, like an encyclopedia because I worked them, but in each and every one of these, a prior attorney turned down the case for what I would consider, a valid reason. It's not like they looked at it and they made a mistake. We looked at these things, saw them differently, and were able to make successful recoveries for a client. I'm going to say there are probably clients that at some point in time we would have gotten out of that another attorney may have found something on. So I'm not here to throw dirt or throw stones or anything like that.
No, and I don't. It's not an indictment of other lawyers. I do think that happens less with us turning cases down that other people find to be fruitful. I think we kick that tire and we kick that tire and we kick that tire over and over again and look for any possibility of a fruitful recovery. With that said, I think any lawyer can miss something. I think it happens more often with certain law firms that really focus on volume because when you have tons of volume coming in, you don't have necessarily the right people always looking at those cases. And then a snapshot look at a case with what looks like on the surface a very difficult fact pattern that's not going to be the path of least resistance, easy recovery. Some firms tend to turn those cases down, and then you look at it and you see many different angles to where we can actually have a fruitful recovery.
And okay, so this is not to toot my own horn, but there's really no other way to do this. I'm a board certified civil trial attorney. I've been in trials. I've won trials. I've had 7-figure verdicts. I've done all this. I've lost stuff. I've made mistakes. I've seen it. Right. So when you go to a lot of firms, you don't always have the case being evaluated by an attorney with that level of experience. And a lot of times what you'll have is that an attorney with sort of that level of experience evaluating the case based on the summary of a lesser attorney, someone with less experience, right? What we do is and these are claims. Look, if it's just a simple whiplash claim where 2 attorneys have turned it down, there's not a lot of damages. It's rare that we're able to turn those things into stuff. When you have the more catastrophic type of injuries, amputations, brain injuries, stuff like that, that's the claims that really warrant that second level of effort. So what we'll do is even when a case has been turned down by another firm, I'll start at the very beginning. We re-interview the client. We re-look at the potential for recovery for insurance policies, make everyone send them to us and work it from the ground up, not pick up what someone else has done.
Yeah, we do not like to fly the planes of others that they built themselves. We like to build our own planes.
Yes, and what happens is occasionally as we do that, we uncover other things. Like I can tell you one we're signing up right now, and there's nothing confidential about this because this isn't one that's already settled, right? We've got a case where it involves someone who's injured in an explosion, right? And it's significant injuries. And this is a case that was turned down by another firm because they couldn't find a viable defendant, someone with any money to go after. We brought this in. I think you sent me an email. You said, hey, this could be a good case. Look at this. And I was like, all right, let me pick this up, right? Because she'd come to us from the internet after being discharged by her prior firm. Picked it up. I said, wow, she got some significant damages. when we spoke to her, within 20 to 30 minutes, I already had an idea of 4 different claims that I thought we were going to pursue as a result of this explosion. Doesn't mean that the prior attorney, was doing it wrong. It's just the obvious claim wasn't the easy one, right? There were some other things out there to pull on. So now we brought this claim in, and within 2 months, we're getting demands out for about $4 million. Now, it doesn't mean we're going to collect that, but we've found viable sources of recovery to start sending those out. So when she came to us, it was, hey, I've got nothing, but can you look at this? Right now, we've told her, hey, I can't promise you anything, but here's the 4 paths we're going to go down, and we're not going to stop until we lose. Right? It's not going to be, we're taking the defense's word for it that there's no money. No, a court is going to have to tell us there's no freaking money, and that's, it's really rewarding. And I tell you, kind of smile. You can probably tell I get a little excited about this because I mentioned this to you, right? When someone comes in and it's like the, poor little kid's been paralyzed by a Coke truck, right? Something like that.
That's obvious.
Horrible accident, right? It's horrible, but the only thing you can do is screw that up. You're supposed to hit a home run. Right, you're supposed to get millions and millions of dollars for that person. When someone comes in and they've got a tenuous claim and they've got significant injuries, your ability to make a recovery for them is a much more sort of rewarding experience. Like you've given them something they weren't expecting.
100%. I draw the analogy, and you talked about like path of least resistance that many like to take. It's like when you were younger and you're interested in meeting the opposite sex, you go to a bar, you always had that friend that played last man standing. No matter what you did, when you're ready to pack it up for the night, your buddy would still sit there and he would hope. And he was the one that if somebody was showing any interest, he would actually meet that woman that night because he would not hang it up. He would give every last effort possible. You are that type, and this is not to take away from your quality of your legal acumen. I mean, you're a quality trial lawyer, but you never take the path of least resistance. You stay until the last ounce is like soaked out of that sponge. Like the last droplet is out of that thing. You go after every possibility. And I've seen it on every case that you're on. It's you treat every case as if you have no other cases in your office.
Well, and I can tell you one just recently, right? And you just mentioned it was turned down by 4 other firms in Florida. It was someone we work with up in Illinois, referred down a case. Facts of the case were, our client rear-ended someone going about 70 miles an hour, right? So on its surface, everybody turned that down. You rear-end someone,
of course,
it's your fault, right? Well, when you took time to speak to this guy, our client was actually a very experienced driver, been driving his whole life. He's like, look, the reason I hit this thing is because it was poorly lit and it wasn't moving fast enough. Right. So, hey, well, I can run with that. If you're driving a vehicle on the road, it's got to be roadworthy. Right. So we took a roadworthiness defense or angle on that. We made a recovery for this guy. Right. This guy put 7 figures in his pocket after everyone else is paid. Like his bills are paid. We're paid. This guy put 7 figures in his pocket after 4 of the people turned the case down. He had real significant issues. Significant injuries, but the best part about it was they had given up hope, right? Him and his wife had given up any hope of making a recovery on this case. And to see him kind of almost tear up when they start seeing you get tracked, that's really rewarding. Now, do I like the check? The check is fantastic, right? We get a piece of every dollar we get, and I like money as much as anyone, right? But the money is out there on every case, right? There's a certain level of reward, warm fuzzies, whatever you call it. That's sort of an extra kick when you pull a rabbit out of a hat, or you really get someone life-changing money when they've had life-changing injuries and they've got no hope, right? It's like, it's a high. I don't know what other way to say it.
No, I mean, these folks have proverbially, they had the door shut on them. Not just one, some of these like 2, 3, 4 turn downs, we get involved and we turn these cases around. Like, what are you looking for? Is there something specific? I know these cases run the gamut of all types of fact patterns, but is there something specific that you're looking for?
Yeah. Essentially, these cases usually get turned down for one of 3 things, right? Someone looked at liability. But hey, I can't build a case where we're blaming anyone else for these injuries, right? So they turn it down. we look at it and maybe find someone else we look at as a responsible party or take a different approach to it. So liability is one of the big ones. The one where the person where we just talked about with our client rear-ending a defendant, that was a liability turned down by 4 other firms. Some other things where you get is, hey, we've got liability, the one we just signed up last week, right? There's liability there, but the other firm that looked at it couldn't find a viable avenue of recovery, right? They couldn't find any money or insurance to go after as a result.
Going back a sec, the liability argument right on surface, just because it's not path of least resistance, not an easy lift, that they're going to have to hire experts and have to really come up with a good legal theory to get around the liability argument. That would, I think, you tell me if I'm wrong, that's where you're seeing most of those cases.
Well, it's not even that. It's like a lot of these guys from attorneys, sometimes they just go, no, you rear-ended somebody, and they don't get much further because you've got, like you kind of said, and I don't want to disparage larger firms. Larger firms have a more rigid protocol, right? You don't have the person who sets these protocols and makes the rules is so far above the person enforcing them, no one can change them, right? So we've kind of got our parameters, but it's you and I who set them. It's you and I who are looking at these cases. If a case doesn't quite fit the parameters, we can bend. We can say, yes, we're taking this, even though it's not our ideal case. When you end up at the firm where, hey, someone at the top, that the person evaluating the case doesn't have access to, someone sets these rigid requirements, the person who's evaluating the case doesn't have the authority or the ability to alter those, right? They might go, yeah, I'd like that, but I can't do that. Another thing, right? We get cases. One that was kicked, we got $2 million for. It was in Florida. This is one where it was a causation issue, right? Liability looked clear. The prior firm had worked up our client's case to the point of litigation. And then they said, look, we don't want to spend the money to litigate this because we don't think the injury could have been caused by the incident. Right. So client called us and he's like, look, they said it couldn't have been caused by the incident. He called me. He's like, it was. I'm there. I'm telling you, it wasn't caused by anything else. I know I was there. This is a client that had a history of drug and alcohol problems as well. So his credibility may have been somewhat suspect. I can tell you when we picked up that file, I want to say the first offer we had on it was $15,000. The ultimate settlement on that file was $2 million. So, and what it did, it just took us listening to the guy go, okay, if he says this truth, let's look at it. Let's get the experts. Let's hire someone to say, what kind of force would have been put on this guy's spine as a result of the incident he went through.
I remember this. I know what case. I was thinking what case we talking about. I got it.
Yeah, well, I can only say so much because a lot of these are covered by confidentiality type of things. So,
sure.
I can't say anything.
I said that in the beginning. You got to thread the needle on that one, so I'm leaving that to you. Yeah.
So that's what happened. They didn't really see a causation issue, and we saw it. We worked it up. We hired the 2 different engineers to work up the causation. Talk about the forces expended on the spine. Came up with a $2 million recovery.
If I remember correctly, the defense was taking it so unseriously that they didn't bother investing in an expert.
No, they didn't, and I can still remember the smug look on the defense attorney's face during the first mediation when we first got involved. Just dismissive, everything else. Right now, this guy got fired by the time we went through the second mediation, so he wasn't there. But I could tell you, I told them, and you could see the letter I wrote to him. I was like, here's what's going to happen, right? And I hate to say it like this, but I told you, I'm coming to kick your ass in 3 separate steps, right? 1, 2, and 3. Here's exactly how it's going to happen, right? And I did it. We did it 1, 2, and 3, exactly like we said we would. And when it came to settle this, the judge that was involved in this settlement walked up to him. He goes, yes, when you screwed this up, it's when you didn't listen to that letter. The judge told him that. He goes, that's when you screwed up, when you didn't listen to what he said in that letter. Now what are you going to do? Right?
What did the lawyer say?
The lawyer paid us. He said, hey, let me give you a check. right? Because it was the guy who was handling it, and
I know he did that, but what did he say to the judge? Anything? He respond?
No, he was fun. The guy who was handling it, and this happens a lot, right? And this is sometimes why we get cases too. The person who's handling it will look at it and go, "Oh crap, this needs to get done," but the person with the checkbook is so far above them, right, and so removed. They're like, "No, you can't. Just defend it. Just that's crazy. We're not going to pay that. Just defend it." Right. So they that's what happens. The guy who's on the ground is going, no, but they say it's not causation. We got a great causation defense, right? It happens, right? So each and every one of these people, they were
like hopeless 100 times.
Yes. And then we got one other guy. We got one, and it was done between 2 and 3 million. This got discharged by a local firm not because of the incident, not because of the liability, but because our guy had a drug problem. He had a significant drug problem that made him a very difficult client to control, right? You got someone who's, on and off of drugs, emotional, taking out loans, spending money, doing all this stuff, right? But and he was truly a pain in the ass for a long time
until he cleaned up.
But beyond that, right? Mm-hmm. It doesn't change. Like, and this is something I hate. People really, like. People come wherever you're like you may be a drug addict, you may be a prostitute, you may be a preacher, you may be a father, you may be a mother. Okay, no matter where you are, you've got the right to not be run over and injured, right? So,
fair point. And we take our clients as we find them.
Yes, and and I hate. And I get this. I hate it. And nothing makes me mad when the defense is, well, your guy's a piece of shit. Right? He just deserved this to happen to him. He's a piece of shit. I mean, I hate to say it like that, but that's the defense we get.
No, they literally say pretty much that. Yeah.
The code word, right? You don't say he's a piece of shit. They say he's
not
verdict worthy.
He's got a colorful history. You're never going to want this guy in a courtroom. I mean, I've heard that 1,000 times. Sure. Right?
The key for verdict worthy. This guy's not verdict worthy, meaning, hey, we don't think a jury's going to like him and give him any damn money. Right? Well, what you got to do is you got to see that the jury is awarding someone based on their injuries, not based on their personality. Mm-hmm. Right? Now we got to make someone. You don't want to stand up and have the jury think they're an asshole, right? You can't do that. But to the extent there is an aspect of the claim where the person is injured, who no matter what happened to them, no matter what their attitude, they're entitled to compensation for that.
100%.
This guy ultimately cleaned up. He became a great guy. We got him life-changing money. Like, I mean, this guy sends me text telling me he loves me now, not in like a homosexual way, right? But he's like, I know this sounds weird, man, but I just want to tell you, I love you, right? And just, he's big in the recovery field. He's big into helping people. And he just looks around at where he was at. When he came to us, what his life was at and where he was, and then like, where his life is at now, this is just cool. It's weird, I'll get some text from him at times, but I can't tell you, every time I get it, it's super, super rewarding, right? Like this. Sure. So, and I say that not to toot our home, but look, if you've got a claim and you've got significant injuries, I don't care what the claim is. If an attorney, if 2 attorneys, if 5 attorneys have told you no, talk to the 6th. Give us a call. Give anyone a call. Just keep looking, right? If the injuries are bad enough, if your life has been changed, if this is something you're grappling with on a day-to-day basis, do not stop looking till the statute of limitations runs, right? Keep looking until you can't look anymore, and there's going to be no time. Anyone wants to call us, I don't care if you've been turned down by 10 other people, we're not going to tell you we won't look at it. If you've got the injuries, we're going to dig deep enough to see if we can pull a string and find something.
100%. I mean, we could beat this subject to death. I just want I always like to keep these videos somewhat short and sweet and palatable so we can digest it. What closing points would you like to leave the viewers or listeners with? Like, if they've been turned down, I mean, speaking to the wider audience out there, their case has been rejected by so-and-so law firm. What's the next step? What does that really mean?
Okay, well, people got to realize, right? For most people, I'm going to know a lot more about the law than they do, right? A lot more when they come to us. I don't know more about the claim than they do. They know why they've brought a claim. They know why they contacted an attorney. They know why they thought someone else was at fault, right? So if the arrogance that you've got because you know the law overrides your ability to listen to someone who understands their claim, you're going to miss the theories of liability, because they're the ones that understand all the little nuanced stuff. So
Well said. Well said.
yeah, it's don't let your arrogance and your knowledge override the client's understanding of what happened to them.
Well, that's your lesson to the lawyers out there. What's your lesson to the clients, though? The individuals who've been rejected by ABC law firm down the block, or big case, maybe an Orlando law firm or Tampa law firm, Miami. We handle cases statewide, even nationally.
Really easy, right? That attorney that told you you don't have a claim will never, ever, ever, ever be the one that decides what you would get in court, right? Because he would never sit on a jury. The person who could sit on a jury is you, that person making the claim, right? You're the one who would decide if someone else got money, not that attorney, because the attorney never make it to the jury. So if I can sell this to a jury, if it resonates with the normal person with a theory of liability, and you are the normal person, you're the person that could sit on the jury. If it resonates with you, I might be able to get a jury. It might resonate with them. So don't just defer and think that because your attorney told you something, this is the be all, end all, and it's game over. Keep looking. I can't tell you how many stories like the 3 we've just told you are out there. I mean, there's hundreds and hundreds and hundreds of them. Keep looking, keep calling. Don't give up, because, I can't tell you, these are the most rewarding cases we get to do in our office.
Understood. You're a phenomenal guest, Mr. Gipe. Normally we don't interview each other, but I thought this was definitely an episode-worthy podcast, being that there's so many clients out there who come to us for a second or third opinion, who those are people who come to us. I can't imagine how many just become discouraged and just lose hope and never pursue their claim because they took whatever the first attorney told them.
Anyone with the catastrophic injury from an incident should get it looked at, right? You just, sometimes things are your fault, and that just happens. Mm-hmm. Oftentimes there's other contributing causes that you may or may not realize. There may be safety standards for things you use that you don't realize. So always have people look at it, right? Even though you may blame yourself, fault, right? It is not an on-off switch. It's a percentage. Right? You can be 60% at fault. Someone could be 40. You could have 40, 40, 20. You could have 5 20s. It just has to add up to 100. So it's not an on-off switch. We would love to talk to you if you find yourself in a boat where you've got a catastrophic injury and someone has told you they can't help you make a recovery.
Well, appreciate having you as my guest today, Stan Gipe. Great partner, but normally I don't interview you, but I thought this was a great subject matter to cover. So thanks, Stan. And I appreciate everybody listening to our podcast. This wraps up another episode of the David vs. Goliath podcast. I'm Matt Dolman. This is my business partner, Stan Gipe. Have a great day.